I'm Rob Hulls and I'm the Director of the Centre for Innovative Justice at RMIT University, and I want to welcome everybody to this fabulous Law Week event, Demystifying Restorative Justice. Just to give you an overview, today's webinar is going to examine the many ways restorative justice practices are currently being used in our community as a response to harm. At the CIJ, we've always had a real interest in restorative justice. We see it as a way to respond to harm and the needs of people who have experienced harm in a way the criminal justice system and other processes don't, and often can't, I have to say. By hearing from some of our staff who are involved in restorative justice, we want to highlight how restorative justice is already being used in a variety of contexts to respond to harm. Despite its increasingly wide usage in Australia and overseas, unfortunately there can be a reluctance to see restorative justice as anything other than a fringe response. So in today's webinar, we will dispel some of the myths and misconceptions about restorative justice, and in doing so demonstrate how RJ can directly address the needs of victims much better than in many cases the adversarial system can. It also has something to offer people who are responsible for causing harm, and we believe more widespread usage of RJ will lead to social transformation, shifting of power, and indeed changing lives. So, chairing today's panel is Dottie Armstrong. Dottie is a long-standing member of the CIJ team, working as an advisor, lived experience expert and peer mentor. She works extensively across the disability and criminal justice sectors and provides advice on a range of issues relating to people with acquired brain injury involved in the criminal justice system. She is an experienced public speaker and has developed a very strong reputation for representing a lived experience perspective in high-level policy and practice discussions. She's very well known for her work in disability advocacy and for telling difficult stories, very difficult stories, with enormous impact. In 2018, Dorothy received a Victorian Disability Award for her advocacy work for people with acquired brain injury involved in the criminal justice system. She is quite an extraordinary woman. And Katie Christensen is a restorative practice facilitator with Open Circle. Katie is a Wurundjeri woman, a proud Wurundjeri woman, and I failed at the start to acknowledge that we are on Wurundjeri land, and I do pay my respects to elders past, present and emerging, and First Nations people who are joining us. Katie has extensive experience working in the domestic violence sector, supporting women who have experienced violence in crisis and long-term case management, and facilitating healing groups for women and men who have used violence in the family home. Welcome, Katie. And Stan Winford. Stan is Associate Director of the CIJ. He helped to establish Open Circle, which is the CIJ's restorative justice service. That was way back in 2019, following the success of a pilot program that offered restorative justice to people who were impacted by motor vehicle collisions. In his research and policy work, Stan explores opportunities for using restorative practices to meet the needs of bereaved families within coronial systems, people impacted by serious crime, and people who rely on workers' compensation, occ health and safety, and transport accident compensation schemes. Stan facilitates restorative processes for the Commonwealth Ombudsman and the National Redress Scheme, and he also teaches law and social work students at RMIT and has studied restorative justice in New Zealand, training of accredited by the Australian Association for Restorative Justice, specialist training with the Canadian Community Justice Initiatives in Restorative Justice and Sexual Harm, and convener training with the Department of Youth Justice Queensland, and training on restorative justice and serious crime with the European Forum for Restorative Justice. So he has some real expertise, as do all our panel, in restorative justice. Before I pass over to Dottie, I just want to let you know that we will have time at the end for questions, and Melanie Jewston, a Senior Policy Advisor and Restorative Justice Facilitator with Open Circle, will be keeping an eye on the chat, and if we have time at the end, she'll put some of the audience questions to the panel, so please put your questions in the chat if you have any. It's now my great pleasure to pass on to the convener of this Law Week session, Dorothy, also known as Dottie Armstrong. Over to you, Dottie.
Thank you very much, Rob, for that wonderful welcome and introduction to us all, and thank you and welcome to everybody who has joined us today. It's a great pleasure. So I'd like to start by saying that today's session, I have a list of myths and misconceptions that people sometimes have about restorative justice, what it is, and I'll be directing my questions to either Stan or Katie, and either of them can answer for each other if they'd like to. So I'd like to start with the first myth, and this is directed to you, Katie. Restorative justice is something that benefits the offender. It might get them a shorter sentence or make them look good before the court. Because of this, restorative justice has nothing to offer to the victim. Is this true?
Thanks, Dottie. And yeah, just like to extend welcome to everyone joining us today. I think it might be helpful to just start with setting out the language that we use. As a restorative justice process isn't a criminal justice process, instead of using terms like offender or perpetrator or victim, we use the terms person responsible and person harmed. When we're working in the context of sexual assault or sexual harm, we are using the terms person responsible and victim survivor, because that's what we hear victim survivors would prefer to be named as, so that's what we go with. So they're the terms that I'll use interchangeably today. So in terms of the benefits for the person harmed, restorative justice is a person harmed centred process. And so often these processes begin with conversations with the person harmed. And so that's the foundation that every process is built on. So what that means when it's happening in real time is that we're asking ourselves, facilitators are asking ourselves at the beginning of each process, what are the victim and survivors' hopes for the process? What's motivating them? What's drawing them to a restorative justice process? And then we're asking, can restorative justice meet those hopes or needs or interests? Is that something that a process can fulfill? And then finally, we're looking at, can the person responsible or the representative of the organisation for the person responsible meet those hopes or needs? So we're really building everything around the needs and interests of the person harmed. What we know about victims' justice needs or interests are that they're quite often, there's a really specific set of things that people are often interested in. So the first one being voice, so the opportunity to speak to what happened, to perhaps talk about the ongoing impacts that they're living with, and really having that opportunity to tell their story. Another one is validation, so being able to speak their story without it being questioned or minimised, and have the validation of it being heard. Obviously, accountability. People want the person harmed to take that responsibility from them and hold that responsibility for the harm that's been caused. Another one is information. So quite often when a harm has occurred of varying degrees, people have some questions around what has happened in that incident of harm, like, why did you pick me? Why did you pick my house? What thoughts do you have that led you to think that this was okay? So quite often in these processes, we can see people are seeking some kind of information. Prevention is another really big one that we see a lot. People think that if they speak to what's happened to them and what it's changed their lives, that the person responsible might think twice before doing it again. So there's a real need to prevent that harm happening again in the community. And then another interest that we see is resolution. So not closure as such, but resolution in that after having a conversation, the whole incident can kind of be brought to a close of some sort. And when we're thinking about restorative justice, we see that it has the potential to offer all of those things to a victim or a person harmed, and we definitely see that as beneficial. If we're thinking about the criminal justice system, the central focus is really on what law has been broken, who has broken that law, and what is the appropriate response or punishment for that. So when we're thinking about those needs and interests, we can see that not many of those are considered, except perhaps voice through a victim impact statement, and perhaps prevention or community safety if in the instance that there's a custodial sentence handed down. We also know with the criminal justice system that there's a real potential for the victim, survivor, or the person harmed to experience further trauma or further harm within the criminal justice process, particularly in the context of sexual harm, which I think we'll probably get to a bit more later. And I think, we've all heard people say things like, oh, the trial was worse than the assault. In Victoria, outside of youth justice conferencing, there isn't much benefit legally. We're not running processes until criminal proceedings have been finalised here. So it's not like people are going to get off lighter or anything like that. So there's little benefit there. But we do definitely see benefits for the person responsible, but probably not the ones that you think. So we're thinking that a benefit is the gift of accountability. So being able to face the person that you've harmed, having the opportunity to offer a personal apology, the opportunity to realign with your values when you've done something wrong, to realign with the values and the person that you want to be. So yes, and we see those as quite profound benefits, but they're not necessarily benefits in relation to that idea of getting off easy. Thanks, Dottie.
Thank you very much, Katie. I think you have really clearly highlighted, and I love the word you used about profound, the profound benefits of restorative justice. Thank you so much. So the next myth I would like to pose is to you, Stan, and that is that restorative justice really only works for less serious crimes. It's most suitable for young people involved in things like shoplifting or graffiti, but it doesn't work for more serious offences that involve real harm to people. Is this true, Stan?
No, it's not true, Dottie, and I think the perception's understandable, particularly for people in Australia, because here restorative justice really took hold as a response to youth offending, and most of the time restorative justice, and it's currently the case that restorative justice is broadly available in most of Australia in relation to youthful offending. Now, when it's taken up in response to youthful offending, people think, oh, that means low-level crimes, and also it means focusing on rehabilitating young people. But actually, restorative justice is more than just about rehabilitation or preventing future offending. And in other jurisdictions internationally, it's always been used for more than just youth justice. It's been used to respond to much more serious forms of harm. And the research is really clear, actually, that restorative justice probably has the most benefits when it's applied to serious forms of harm and crime. So we've got Australian research in 2006 by Heather Strang, which found that victims from diverse backgrounds who'd experienced offences that ranged from minor to very serious consistently reported feeling better after taking part in RJ processes. So, whether it's serious or not, everyone felt better. And another interesting piece of research from the UK compared 3 different schemes, and the Ministry of Justice research found that victims of serious offences were even more likely to be satisfied with their experience of an RJ process compared to victims of less serious crimes. So I think people also maybe are a little bit concerned about, if it's a really serious crime like, a murder or a rape or something like that, that it must be more dangerous or risky to bring people together in a facilitated dialogue. We would say, and you'll probably hear more about this later on, that a trauma-informed restorative response that allows dialogue between people harmed and the person responsible actually can address that serious harm. And also, when you heard Katie speak about justice needs, well, what we would say is that when there's been a really serious harm, then there's probably greater need for a response to those justice needs. So it is actually, in our experience, and we do a lot of practice in this space, that where there's been a serious harm, including the loss of human life, that the process can be most beneficial. And I think road trauma is a really good example. So we've done a lot of work looking at what happens when someone dies or is seriously injured in a motor vehicle collision, and the effects of that on the people injured, on the families who've been bereaved, the friends of the deceased. That kind of harm manifests in really serious trauma. And in fact, there's a term for it called traumatic bereavement. It's a particular kind of grief. People view the loss of their loved ones as being senseless, irrational, and often people find that the criminal justice response is inadequate. And it can be seen as very inadequate when thinking about things from a legal perspective. The level of sort of culpability on the part of a driver, for example, isn't matched by how serious the harm is. So, you know, people can die as a result of inattention on the roads rather than, you know, really serious culpability that involves using drugs and alcohol and incredible recklessness. So in those circumstances, often families and others are thinking this response is just not matching the significance of the loss and our bereavement. And Katie, I might ask if you could give us an example of one of these types of processes to help illustrate that point. Over to you, Katie.
Yeah, thanks, Dan. We recently facilitated a process sort of like what you're talking about, Stan, where there was it was just a really horrendous accident. So 2 families taking a drive in the country. No one's tired. There's no drugs or alcohol involved. Due to a moment of inattention, one car has crossed over onto the other side, and the 2 cars have collided. And so in this process, we had a man and his pregnant wife and their 5-year-old child in one car, and a man and his wife in the other. And both of the partners were lost, and the pregnant woman died also in this accident. So it was absolutely horrendous and tragic. And so one man was at fault because he crossed the line. But yeah, it was one of those mistakes that, you know, we've probably all made, like, you know, driving on a country road and kind of drifted over and then just gone, oh, whoops, and, you know, corrected ourselves, and hearts have thumped a little bit harder, you know, and kind of brought us back to the road a bit more, but we've somehow managed to not end up taking a life. So it's one of those things that's just a terrible, terrible accident. So the man who wasn't deemed responsible, he reached out to us. There had been a criminal proceeding, and he really just wanted to speak to the man responsible. So he started the process as is usual, and his hopes were he really wanted to meet the man and let him know that he knew that it was just a terrible accident, and that he wanted to wish him well. Like, that was his hope. He wanted to free this man from the guilt that he imagined he was holding, so that he could better be present to raise the 5-year-old daughter who had lost her mother in the accident, but who had also survived the accident, thankfully. So we met with him and we talked a lot about those hopes, and then we met with the man responsible, and, you know, he was understandably very unsure at first. He really didn't, even though we said, oh, you know, this man just wants to sort of have a chat, he really wasn't sure what his motivations were. He didn't know whether he would want to yell at him or want information that he just didn't have. So he was really unsure, and he went off and he spoke with his support worker and everything, and his counsellor and his family, and he came back quite resolved to do this, and his hopes for the process were that he wanted to be able to apologise to the man personally, and he also wanted the opportunity to thank him for his victim impact statement, which had, you know, quite a big bearing on the sentence that he had received. So he wanted that opportunity to thank him, and he wanted to give him whatever he could in the process. So together, their shared hopes were to share those experiences of grief and loss that they had both experienced. I remember the man harmed, or not responsible, had said to us in one of our preparations, he said, we're twin widowers bound by 2 terrible seconds, and so there was a lot around wanting to kind of explore that experience together. And so when we did bring them together, and it was quite quick, we only had a few preparation sessions with each of them. When we did bring them together, it was that opportunity to speak about what their memories of the actual accident were. So they both had a turn at talking about that. They spoke about their experiences of recovery from injuries. Like one had to kind of go straight back to life, even, day-to-day life. He had a child, he had to get on with all of that and all the criminal proceedings. But he did have injuries as well. And the man not responsible, he spent quite some time in hospital. And so they both spoke about the recovery from those injuries, and they both spoke a lot about their experiences of grief between the accident and the present day. And I think having that conversation really allowed them to share what they need, like share their experiences and have that grief and experience witnessed by the only other person they felt would understand. So, the man responsible was like, I can't speak about this to anybody else. Like, this is the only person who would understand. So yeah, it was an opportunity for that, but it was also an opportunity for them both to really honour the women in their lives that had been lost to them in the accident. They spoke about putting flowers on graves and things like that. It was really a beautiful demonstration of compassion and shared experience. And when we were reflecting with both of the men separately afterwards, the man who was responsible for the accident said, it's a thing that I have carried in my heart and in my head, but now I feel so light. He's really a good man, and I really hope he feels good after the meeting. And the man not responsible said, I unexpectedly feel laden with gifts, both physical and metaphorical, because he'd been given some flowers by the man responsible. But he also felt that, going through that process had been a real gift to him. And, it was just something that they weren't able to achieve through that criminal justice system that had already occurred. Thanks, Dottie.
Thank you very much, Katie and Stan. Really heartfelt examples of how restorative processes work. Okay, so I'd like to move on a little bit and talk about myth number 3. Sorry, it's very hard. I'm still dabbing my tears. It's incredibly beautiful. So restorative justice is a feel-good process through tears. Sorry. That requires the victim to forgive and to become friends with the offender and to see things from their point of view. Katie, does that match your experience?
No. The short answer is no, it's not true. It's not a requirement at all. Restorative justice doesn't require the victim to forgive the wrongdoer or become friends. And we would never encourage either of those things. If they happen organically, that's fine, but we would never encourage that sort of stuff. And, in many restorative justice processes, sometimes people don't even meet. Sometimes it's a letter exchange. It's really whatever the person harmed or the victim survivor is most comfortable with. But there's definitely no requirement for friendship or forgiveness. The focus is more on that facilitated conversation where the person harmed, their needs and interests are addressed. And so not about how you feel about the person responsible, but, how you're feeling about those needs and interests being met. I think, when a harm occurs to us or an incident happens to us, it can really change the way that we see ourselves, and it can really change the way that we feel about ourselves. one of the hopes of a restorative justice process is that it will help to restore your relationship or view of yourself as a person harmed. I think I kind of touched on it before. People harmed can often sort of carry that responsibility for the harm or the blame, like it was my fault, I did this, I brought this on myself. So there can be that real carrying of responsibility. And, restorative justice can be an opportunity for the person responsible to take that back from the person harmed via validation and accountability. So that can really change the way people see themselves. And we certainly hope it does. Just talking about that example between the two men, we obviously really hope that there are some feel-good aspects within the process. And we do find, that through the facilitated dialogue, the person responsible is often humanised. So, when somebody has enacted a harm, it's very common that the person harmed will kind of have them in like some kind of monster in their mind, and we do that in society. When people have done something wrong, we demonize them straight away and we totalize them with that act. But when through the facilitated dialogue, through sitting across from the person responsible, we do see that they become humanized, and we often hear things like, oh, I built them up in my mind to be some kind of a monster, but they're just a person sitting across from me and I'm not scared anymore. So we want there to be feel-good aspects, but we don't encourage friendships or forgiveness. If those things happen naturally, that's between the two people in the room, not something that, not a hope for the process. Thanks, Dottie.
Thank you so much for that wonderful explanation, Katie. And Stan, I would like to pose this myth number 4 to you, and that is that restorative justice is really expensive and it just takes too long. Is this true?
No, I feel like you might have guessed my answer was going to be no there again, but it's actually quite inexpensive. And in terms of how long it takes, well, as you've heard from Katie, it takes as long as it takes. And that's because the amount of time it takes depends on when those participating are ready, willing and able to participate, and when it's the right time for them. And I suppose if we contrast this with the conventional system, timelines are there, but they're often driven by external factors. So, what does the legislation say about when someone needs to be charged? What's the court's timetable for clearing its backlog or getting through the list? Those sorts of questions. So, yes, it can take time, but if we want to have a process that's safe and effective and people are properly prepared to participate, and also it's completely voluntary. So, it's not like there's any point doing it when people are not ready. It just wouldn't be helpful. So that's really my how long's a piece of string answer. But certainly in terms of the cost, I think that is another myth. The conventional approach really involves enormous amounts of spending on police, on courts, on prisons. And let me hasten to add that I'm not saying that restorative justice should be taken up because it's cheaper. I'm just saying that occasionally one of the barriers that people put up to explain or suggest why we don't have more access to it is that it's expensive. Well, that's simply not true, and so that shouldn't be a reason. And there have been so many recommendations over many years to make restorative justice more accessible to people, and really it does raise a question about why we haven't moved further down that path, because the evidence about the cost in Australia is this. In Queensland, the program, members of our team have done some training with the team that do restorative justice up in Queensland. KPMG undertook a review in 2021 and found that the restorative justice program up there was 33% more cost effective than court processes. And over 5 years, it was estimated to save $106.4 million related to reducing reoffending, time spent in custody and diversion from court processes. In Victoria, we have got a youth group conferencing scheme. So we've got restorative justice for young people in the youth justice system. Again, KPMG, one of the big four accounting firms and consultancies, did a review in 2010, and they found that for every $1 invested, at least $1.21 was saved in the immediate and short term. And they said this is a massive underestimate of the actual saving. This was just at that time. There's even more recent research. In 2023, Swinburne University looked at youth conferencing in Victoria, and similar to earlier reviews, the research found that it was considerably cheaper than spending money on locking up young people, which costs about $5,000 per day, not including the enormous capital costs of building youth detention beds. So people might be aware that recently we've constructed a new youth detention facility called Cherry Creek that cost $420 million for 130 beds. So we're talking enormous amounts of money spent on the conventional system and relatively inexpensive restorative justice options by comparison. And again, coming back to that question about, is cost really a barrier? Well, in the ACT, one of our territories in Australia, in New Zealand, in the UK, and in many Canadian states, restorative justice programs have been operating for many years. So presumably those governments can afford to fund restorative justice. The other thing to note is that restorative justice can be provided both by government and by community providers. So Open Circle, our centre, is a community-based provider, and there is also a government provider that provides restorative justice. So there's different models for how it can be funded, and as you might expect in the community sector, it can be done relatively inexpensively. I just want to sort of, again, come back to that question about financial arguments and the broad benefits. So one thing that I always found really interesting, and some of our facilitators in Open Circle have backgrounds as sexual assault counsellors, and they work in those fields and they have worked in those areas before. Often people, even people that we're working with who are supported by counsellors or therapists, say that an RJ process can achieve results that years of therapy cannot deliver, which suggests that there are probably even greater savings in terms of things outside saving money on courts and prisons and so on. It's the saving in relation to victims and their recovery, their health and their social and emotional well-being, which is really probably the most important thing in my view, and probably the hardest thing to recover simply through spending more money on things. And I think obviously beyond the financial arguments, in the context of sexual violence, which is another area of practice for us and our team, criminal proceedings, which are very expensive, don't actually serve many victim survivors. So estimates of less than 1 in 100 people who've been sexually assaulted ending up with the criminal justice response suggests that for many people, they don't even get that option. So we would say that we should make other options available to people, and that they are clearly well worth funding and they're not that expensive. Thanks, Dottie.
Thank you very much, Dan. Really informative. Thank you. Okay, so I think we're just coming up to the last myth, number 5. And Katie, I would like to direct this to you. So this myth is about restorative justice in the context of sexual violence. If victim survivors do restorative justice, it suggests that what has happened to them isn't serious enough to be dealt with by the courts. That instead of making the offender face public scrutiny, it sends the process behind closed doors. How does this hold somebody accountable for sexual harm? Katie, what do you think about this?
Thanks, Dottie. I think this is a really interesting myth because it, from the get-go, assumes that victims are only interested in a punitive response, like getting that revenge, that's what, and getting someone locked away and that sort of stuff. and that's fine if that's what you're after. But we know, as I've spoken about earlier, that like many victims, survivors aren't interested in the public court of opinion or sending people to jail, but rather they're interested in those needs that we spoke about earlier: voice, validation, accountability, information, prevention, and resolution. So building on, what Stan's just mentioned there, we know that victim survivors underreport. We know that they often have re-traumatizing experiences via that police process to get to court and then the court process. And we know, again, as Stan mentioned, that, on the occasions that it does make it to court, that the odds aren't in favour of the victim survivor seeing accountability by way of sentencing. The burden of proof is on the victim survivor to prove that the person responsible has broken the law. And we know that with the nature of sexual assault, that proof often doesn't exist due to a large range of reasons, which I'm sure you're all well across. So when we're thinking about, accountability in the context of restorative justice, for the person responsible, a large part of the process is about accountability. When we're preparing for a sexual violence process, we spend a lot of time in the preparation phase. We're working with the person responsible, and we bring in often an accountability specialist to help support that person responsible to step up and into accountability. And what that looks like is actually naming the actions that they took up that leading up to the incident to expose how they have orchestrated the assault. Thinking about, the soup of ideas and beliefs that we all grow up in society, and exposing those ones about women and about entitlement to sex that we know they're all alive and well. We know that they exist. So really, in that preparation process, there's no hiding from the person they've harmed, and there's no hiding from themselves and their own behaviours. That's really stepped through in a supportive way. We feel the process is a real meaningful opportunity towards behaviour change and rehabilitation in a way that I think the criminal justice system just doesn't have the resources to do. Another thing about restorative justice within the context of sexual assault is that we know victim survivors want this. And even in, today's day and age where discussions around consent and, people are a lot more savvy, the young people responsible for harm are also wanting this process. And it's happening despite there being a lack of legislation protecting the process like there is, say, in New Zealand. We are getting referrals from the CASAs, the Centres Against Sexual Assault. We're getting referrals from the community, from people who have heard about the work that we do. So, when the victim survivors are asking for this as a response to what has happened to them, if they know that this is the response to fulfil their justice needs or interests, like whatever they're looking for, I have to wonder why that isn't enough. And for us at Open Circle and Centre for Innovative Justice, ultimately, we always think that broadening those options and access to justice, whatever that looks like, is the most empowering thing for people who have experienced sexual harm and had that experience of such a huge, tremendous loss of control. So to have control over what their access to justice looks like is really important. Thanks, Dottie.
Thank you again, Katie, for that wonderful explanation. And I'd like to turn back to you again. I'm sorry, peppering you a bit. But so just, maybe a last follow-up is to just say that, or to ask, is restorative justice a soft option? Does it let the person responsible causing the harm get off too easily?
That's a good question, Dottie, and quite a common one, I think. Look, I don't think so. I think that sitting across from another human who you've harmed, who is powerfully sitting in their vulnerability, and your job is to sit there and witness that harm that you have enacted, like rippling off their body. I think that's really hard. I don't think it's soft. I think accountability is really hard. It can be. I think, you know, as a society, we talk a lot about wanting accountability from people and from our leaders, particularly. We want people to be accountable, but I think we rarely actually see it in action. And so I think, you know, when people might think that restorative justice is a soft option, there's that confusion of accountability with punishment, you know, equating the two when they're not. I don't think they are. And some people want the person responsible punished, and that's fine, because we know that justice needs and interests are really varied. And so we know that those options to respond to those needs should also be varied, right? We've got Koori courts for First Nations folks who to go through court, and, you know, we hear participants of Koori court saying where they have to go and face their elders, the people that they have grown up with, you know, in community, who they will continue to live with. And they have to go face their elders and be accountable for the things they've done. And they say it's much easier to go face some random judge who they'll likely never see again than face their elders. True accountability to the people you have let down or hurt is hard. You know, and I think a good example of that is those victim impact statements. And we know how powerful that they can be for both the person harmed and the person responsible. And if we think of like a restorative justice process is like a victim impact statement on steroids, right? And it actually asks a lot of its participants. The person harmed has to be vulnerable. They're going to speak about the ways that the harm has impacted on their lives, and they have to face the person that's caused them harm. And that takes, you know, a lot of courage. The person responsible has to listen to that harm, see it on the person's face, and listen deeply without any opportunity to defend or minimize their actions or throw off. They have to really look at themselves and they have to look at their actions. When we're getting to that facilitated conversation, that's the icing on the cake. The real work is getting there via multiple sessions for that person responsible, examining their actions and their beliefs and everything that led to enacting the harm. So, you know, I think it's hard work. I don't think restorative justice is a soft option at all, but I really do think it's a humanising one. And, you know, I know I've witnessed that it can be a really profound experience where the best of what we are capable of as humans can happen in the room. So, yeah. Thanks, Dottie.
Again, thank you very much, Katie, for wonderfully explaining that. And Stan, I know you're there, so I'd like to pass to you now. So a question, or a couple of questions I'd like to ask you is, we've heard about some of the benefits of restorative justice, but the question is, why is it not being practiced more in Victoria? And also, sorry, just to follow up to that, what are some of the roadblocks to that, Stan, and how could we make it more accessible to more people?
Thanks, Dottie. Yet another good question. And as you've said, restorative justice is something that the evidence says offers benefits to many people, and it's generally experienced as a very positive process, certainly a far more positive process than a conventional criminal justice process. Yet here we are with very little access for adult victims of serious crime in Victoria. So I think there are some simple roadblocks there. The lack of funding and resources to provide these programs. So there are very few programs that are accessible to people. And the obvious answer to that is that we could make it more accessible by ensuring it's properly funded and properly resourced. There's another practical roadblock, I think, which seems to deter people and does make a bit of a barrier for participation if there are sort of concurrent criminal proceedings happening, and that is the need possibly to legislate to provide a legislative basis for restorative justice. And I think that could help in a couple of ways. One is that it's clear that it's a legitimate option, and you know, restorative justice has very much been a sort of peripheral alternative idea, at least in our jurisdiction. So some people don't take it really seriously. Some people don't see it as a meaningful choice for people that they're dealing with. And formal recognition within legislation could address that by making people aware of it as an option, both professionals in the justice system and also ordinary people. And also it could protect what's said and done in these processes from getting in the way of other legal processes. So, you know, people who are negotiating alongside civil litigation, they can have conversations about settling their disputes that are not then used against them in that civil litigation. Why can't there be something like this for people who are trying to resolve conflict or respond to harm alongside what might be also going on a criminal justice process? And it would be a simple fix, but again, you know, why isn't it happening? Why isn't the government providing legislation or funding to address this? And I think one of the answers is because there hasn't been enough pressure on them to deliver in relation to this. We all know that people, victims, survivors particularly, have expressed dissatisfaction and often anger about their experience of justice. But what we get in response is usually that politicians reach for the tools that they know, the tools that they've used before, the only tools in their toolbox, which is things like sentencing and, you know, changing the penalties, maybe occasionally coming up with something like a victim impact statement to try and respond to things a bit differently. But generally speaking, they're stuck with the same old tools. And part of that is that, just like many in the community, politicians are not aware of what restorative justice is. And many of them probably relying on these myths and misconceptions that we've been talking about today. And look, one of the reasons for that is that it's just really hard to get your head around this if you haven't actually participated in or witnessed a restorative process. And that makes it a catch-22 for us because, you know, there's a finite amount of these things going on and only a few people have been privileged enough to be witnessing them. And often they're the facilitators or the conveners, not an audience. So that is a challenge that we need to overcome. There's also a bit of, I've sensed in our work, a bit of gatekeeping going on. So there are people who work in the justice system in a professional capacity who they see what they're doing as the important thing. And often when we talk to them about, hey, maybe someone in this situation could do with this type of response, and that's what they're asking for, they will often say, no, that's not what they want. But really they're saying it's not what we want because we don't, it's not part of the way we see the world, or it's not part of our jobs to be part of this. So I think we've got to be aware of that. And coming back to how do we explode these myths, but also how do we understand the benefits of them and hear about what it's like for someone to participate in? Well, I think the most powerful advocates are not people like us. We can explain things and talk about the myths and so on, but the most powerful advocates are the people most directly affected. So victim survivors, for example, people with lived experience. And again, the challenge here is that there is so little access available to people that there aren't enough people out there saying, I went through this process, and like all of the research tells us, they'll be saying this was really great and I thought it was exactly what I needed. Those people haven't been given the access and so they can't advocate for it. Mm-hmm. So I think in the meantime, until we start to gradually build up the practice and build awareness of it, of the experience of it for people who can then go on to advocate for it, we really need to reframe the purpose of restorative justice. So as we've sort of addressed in a roundabout way through our responses to your questions, Dottie, I think we really need to think of restorative justice not as in the youth justice context as a way of achieving accountability or rehabilitation only for youthful offenders. We need to understand it as a response to harm that can meet the needs of victims and the community in ways that what's currently on offer through the conventional criminal justice system may not. We need to recognise restorative justice as being about repairing the harm caused by crime rather than other things, such as saving money by offering a cheaper service than what we already offer. We need to recognise that it's not just about reducing reoffending, that it also has benefits for individuals who participate at an individual level. And we also need to understand that it's not one or the other. So just because we all think here on this call that this is a great option, it doesn't mean we're saying that for some people the conventional option isn't what they want, and some people might want both. So restorative justice processes can coexist alongside formal criminal justice processes. I think another important way of thinking about restorative justice is that it's victim-centred rather than offender-focused, that it's voluntary, and also that it's really something that we as a community, if we care about justice and healing, that we should demand that this be available to people who are seeking it. And it shouldn't be compulsory that people who've experienced crime should be forced into only one response to that harm they've experienced, or none at all. Rather, they should, where it's possible, where it's safe, where it's appropriate, be able to choose a pathway to justice that works for them. Thanks, Dottie.
Thank you so much, Stan, for highlighting all those areas for us. It was wonderful. So I'm going to pass over to our lovely colleague, Melanie. But before I do that, I would just like to take the opportunity to say thank you sincerely, Rob, for the opportunity to be the chairperson for today. It's been a real pleasure and a privilege, and also, to work with everybody on this panel today. Thank you. So I'll hand over to you, Melanie.
Thanks, Dottie, for leading us through that discussion. I really enjoyed it. We do have a couple of questions and a few minutes to ask them. Katie, I'm going to give this one to you. Someone has asked, I'm curious if restorative justice is ever done in a collective or hypothetical way. I'm thinking of myself and other survivors who cannot make contact with those who harmed us. Perhaps they've died or we don't know their name. Are there any creative strategies for this kind of situation? So I suppose the question is it possible to do restorative justice without a person responsible for harm?
Thank you. We do like to be as creative as possible here at Open Circle. We love a creative solution to problems. Yeah, look, you can do restorative justice processes. We do a lot of work within Open Circle on direct personal responses, which are like panel work, where there's a representative of an organisation. So, for example, the Army, the ADF, where there's been sexual assault or hazing practices that have harmed people, a representative of the Army will then meet with the person who's been harmed, and there can be a restorative justice process done that way. As far as collectives, like I don't see why you couldn't. We feel like restorative justice is really flexible. We use it in a range of contexts, and certainly, people can be harmed by and speak to a community or a representation of an organisation that has caused that harm. So that's something, that we could absolutely do. So it's just making me really think about the panel work that we do, and we do that for like it might be interesting for you folks to know. We do it, for the Army, we've done them for Services Australia, for Centrelink. We've worked with football clubs like Collingwood in response to racism. So there have been multiple contexts and multiple ways in which harm can be responded to, and it doesn't have to be the person actually responsible, but it can be a representative. I hope that answers the question.
Thanks, Katie. Thank you. That did answer the question, and I think that idea about it being very flexible and responsive to what the person needs shows that it can always be investigated as a possible response. I have another question. Do you think technology can play a role in advancing restorative justice, particularly for people in remote and regional areas? Is conferencing via video an option, or do you think this would not be as effective? Do people have to meet face-to-face in person?
Yeah, well, I mean, I think COVID taught us a lot about how we can, again, be creative and find other ways to do things. For restorative processes, absolutely, we do use video links, and they can still be very effective and emotional and, yeah, really hit the spot for people. You know, I think I mentioned earlier, sometimes people want to do a letter exchange. So we worked with two people, a person responsible and a person harmed, and we exchanged a series of letters over time. And then sometimes you can just do one letter. It might be a letter of impact and harm that's been caused, and then a response to that impact via letter. And that can be really nice because then people have this kind of tangible thing, that this document that stays with them. So that can be really effective. And yeah, people don't have to meet. Again, we're always looking at, you know, what is the person harmed or the victim survivor after, and how can we meet those needs best? So if that means a letter exchange or a video call as opposed to a face-to-face meeting, well, then that's the way it will be.
Thanks, Katie. I think that's about all we have time for. So, Rob, I'm just going to hand back to you to finish up today's webinar.
Thanks very much, Melanie, and thanks, Dottie, for sharing that panel so brilliantly. Absolutely fabulous. Thanks to Stan and Katie. And Katie, I love one of your quotes when you talk about restorative justice not being a soft option, but a humanising one. That really encapsulated. So does your quote, restorative justice process is a victim impact statement on steroids. I like that. That'll stay with me for a while. But look, the evidence clearly shows that restorative justice is cost effective. It can often better meet the disparate needs of victims than the one-size-fits-all adversarial system. And I hope that everyone at this seminar today will help dispel some of the myths associated with restorative justice and actually become advocates, strong advocates for restorative justice, because victim survivors deserve no less. So thanks very much for attending, and we'll see you next time.